Good morning, everyone, and welcome to the 75th episode of our webinar series, 74th episode of our webinar series. And this one is on, again, we are continuing the topic that we started last week on waivers, concessions, and how to manage the same in the IBC. Over to Anil, sir.
Thank you, Ankit. Namaste to all the participants. Today is the part two of the subject that was waivers, concessions, reliefs, and relaxations under a resolution plan, which is permitted under the Insolvency and Bankruptcy Code. This part two is again a kind of very memorial for me because see, today I'm on a 3 days vacation to Pune with my golf friends, and presently I'm conducting this webinar from Pune Golf Club and about to start the game after this webinar. All my friends are waiting. So the moment we finish this webinar, we'll start a golf game. So this is again a memory that this is 74th episode and the next would be 75th without any gap whatsoever may be the reason that we have been able to do this. So in the first part, what we have discussed is that there is no definition of waivers, concessions, reliefs, or relaxations under IBC. There is no section, there is no regulation which deals with it. It is only on the basis of the structure of the overall code and regulations, and the structure is primarily based on the claims. First is the definition of claim under section 3, subsection 10. That definition itself concludes many things that I explained in part 1. Then is the definition under section 3, subsection 11, that is the definition of debt. Then when we see this entire process of insolvency, so these two words are very important. The definition of these two words, like one is the debt and the other is claim, is very important. So these are all being managed under section 5, subsection 21, which defines operational debt, under section 5, subsection 8, which defines financial debt, under section 5, subsection 7, which defines the financial creditor. Similarly, the definition of creditor is also under section 3, subsection 11. So everything is based on the definition of claims and debt. So when a process is accomplished, when a resolution plan is approved, the Honorable Supreme Court has said that there is no possibility of any further claims which can be accepted by the successful resolution applicant. The Supreme Court has also further said that it is not possible that a new Hydra head is popping up every day for the resolution applicant. Once the resolution applicant takes over the company, that company will be on clean slate. So all the old financial liabilities, financial disputes will be completely considered as settled and waived. So whatever amount is being offered in the resolution plan. So there are many things that we actually have discussed based on the overall concept, how the resolution professional will prepare the complete detail of the assets, the valuation of assets, then the detail of overall liabilities, and those liabilities can be matured, unmatured, disputed, not yet crystallized, or it may be contingent. All these liabilities are defined under claims. So any kind of disputed claims are also supposed to be submitted to the RP, and the RP is also supposed to even admit those claims subject to the settlement of that dispute. And in case of some contingent disputes, contingent claims where some liability is likely to come, that also the RP is authorized to admit those claims at maybe any nominal value, maybe at 1 rupee, or maybe as per his own estimate of the total liability of the company. And that estimate liability can be changed further. So based on all this structure, we have seen that the resolution plan would be the final as far as the financial obligations and financial liabilities are concerned, because this is basically a legal entity, and any kind of prosecution, any kind of imprisonment that would not take place with the company, that will take place to the old suspended management and also the key managerial personnel. Now, today, we are sharing with you the next part of it, which is Regulation 37, and that actually is the only regulation in the CIRP regulation which talks about what are the measures which can be taken up and which can be approved by the Committee of Creditors under the Insolvency and Bankruptcy Code. So, the sharing my screen, so we actually go to the subject. So, if I continue, I will go to straight to my slide number 19, because the first few slides are not important today. So this is the Regulation 37. A resolution plan shall provide for measures as may be necessary for insolvency resolution of the corporate debtor for maximization of the value of its asset, including but not limited to the following. See, Ankit, today, in fact, we would like to seek lot many questions from our audience. They would actually ask us the questions, what kind of liability would be waived and what kind of liability would not be waived. So based on that kind of questions, we will try to give a clarity on what is possible to get waiver, what is not possible. Now, these Regulation 37, in case we see this structure of Regulation 37, it is very clear that when this law was made, it was basically intended that any company which is kind of a insolvent, wherein the company is insolvent, so there is a possibility of restructuring, there is a possibility of uh, revival package. So the Regulation 37 is kind of made as a revival package. All those uh, historically we've been dealing with the various kind of options to restructure the financials of a company for making it viable and for making it feasible, and also for servicing of debt. So in case we see, like the as far as the first line, which is the like a transfer of all or part of the assets of the corporate debtor to one or more persons. So this first line is from the regulations, and all other uh, bullets are basically out of my experience, and that's what I understand about the this particular sub regulation A of 37. Similarly, there are regulations up to M, and all those regulations we would be dealing with today. This is the again one line is in the regulation and the other is our own experience. Now, when we see this transfer of all or part of the assets of the corporate to one or more persons, so a resolution plan can also say that we will be selling non-core assets and we will be making major part of the debt by sale of by realization from non-core assets, and the main business assets finally would be operated upon, the business would be revived, and the debt would be reduced, and that will be a serviceable debt. This can be also one of the revival package. Then again, somebody can say that the sale of the expensive land, somebody had a factory in Okla, and now he see that the factory is now, we are able to sell that factory for 30 crore. And then the factory can be shifted to Bawal or any other places where the land is not that expensive. So selling expensive land and shifting the operations to a rented place or to a remote place where the land is less expensive. So that money can be used for payment of some part of the debt and then making the debt service able. That is also one of the revival plans. This is possible in a resolution plan. Sale of the entire business asset to a strategic investor with or without transfer of debt to the new investor. So the entire debt can be sold, and the new person can come in, and the new person like an ARC can come in or a strategic investor can come in, and that can also be one of the resolution plans. Any one vertical, any one segment of the business can be sold, some cash can be generated, and that can also be a resolution plan. And the creditors can also take one-time settlement, and that one-time settlement with the involvement of a third party, that can also be a resolution plan. No, the uh, sub-regulation B says the sale of all or part of the asset, whether subject to any security interest or not, when we are in resolution process, all the secured creditor and unsecured creditor will submit their claim. In that manner, it is irrespective of the security interest. In case we have a proposal to sell some of the assets, the creditors will approve it in a committee of creditors, or otherwise, in case the company is not in resolution process, this kind of decisions can also be taken by the creditors in their own banks as per the bank policies. So this is also possible that whether the security interest is there or not, the same thing as we have seen in sub-regulation 1 can be possible even for those assets where the security interest has already been created by any bank. Restructuring of the corporate debtor by merger, amalgamation, and demerger, that also sometimes becomes a kind of uh, way to rehabilitate a company or revive a company or to make it financially feasible company. That way, we can say that the even amalgamating with a larger company, merging with a larger company, or demerging into two businesses, one is sold and one is not sold, that can also be part of the resolution plan. Substantial acquisition of shares of the corporate debtor, like this is the normal acquisition of a resolution, acquisition of a resolution asset through a resolution plan, where the existing shares are either extinguished or existing shares are either transferred. I mean, that can be substantial or full. Now, why this word substantial acquisition has been used? Like it can be 100% also, or it can be a particular percentage, which is uh, assuring the management. So this goes to the new management. So this can be with a strategic player, this can be with an investor. So this also is, or this can be a successful resolution applicant. That strategic investor, strategic player can be called as a successful resolution applicant. So in the case of listed companies, in case we try to acquire these shares, then we actually have to go by the SEBI uh, regulations. We have to comply with SEBI regulations. Now, the other, which was inserted later, sub-regulation CA, which says the cancellation or delisting of any shares of the corporate debtor if applicable. So, what I'm trying to say is, what is a resolution plan? What all those things are also approved along with the resolution plan? Anything which requires an approval of shareholders, anything which requires an approval of debenture holders, anything which requires approval of the creditors, these three things would not be required in a resolution plan. This process, because of this process is something which is considered to be, in case the resolution plan is approved, it is binding on the creditors, it is binding on the shareholders. So anything which is binding, on the shareholders, that can be done. So maybe that why we are saying that the merger is possible, because in a case of merger, amalgamation, or demerger, the two kinds of approvals are required. One, the approval of shareholders. The other is the approval of board of directors, the approval of the creditors. So all these three approvals would be considered to be uh, available or given in case the resolution plan is approved by the committee of creditors. So wherever you think that we have not been able to conduct a shareholders meeting, we have not been able to conduct a creditors meeting, we have not been able to conduct a debenture holders meeting, all those things are possible under a resolution plan if it is approved by the committee of creditors, because the shareholders also have filed their claims, or even their claim is recognized by the RP. The creditors have also filed their claims and it has been admitted by the RP. So whatever the resolution plan says, that actually will be voted upon and they will vote upon. And this is where the whole concept of waivers and concessions also lies. Anything, any compliance where shareholder approval or the uh, or the creditor's approval is required, that will be considered to have been given to the company. However, after these two approvals, if there is any government approval is required, that can be taken up by the successful resolution applicant, considering the objective of the insolvency law. Now, in this new regulation CA, IBBI inserted the cancellation or delisting of any shares of the corporate debtor if applicable. So this is also normally a part of a resolution plan, which says that the existing shares either can be extinguished, or it can be reduced, or new shares can be allotted. So all this is possible because for all this, the shareholders and the creditors' approval are required, and they both are part of the process that is considered. The shares can be cancelled also, and the shares can be delisted also from the stock exchange. However, the SEBI will not ask for the approval of creditors or approval of the shareholders. Once this process has been done, the SEBI will ask for the other document. The SEBI will ask for the other kind of diligence required by SEBI, but they will not ask for a resolution from members or creditors. Similarly, satisfaction or modification of any security interest in a resolution plan, we can take away some of the security with the lenders, and we can also add some of the securities. We can modify the charge. We can even extend the repayment. So all this is something which is possible. Curing or waiving of any breach of terms of any debt due to the corporate debtor. So this part is important, because see, wherever there is any breach of terms or a breach of contract, so the one is that the claimant waives that, and the other is claimant converts that into financial liability of the company. If the financial liability is there, that will be settled through the resolution plan by way of filing a complaint and by way of offers made in the resolution plan. So in case it is not a financial, so this is something which is really possible, that any kind of deficit in promoters' contribution the banks might have highlighted in the past, that can be waived. Siphoning of the funds or the promoters can be waived. However, this will be subject to section 43, 45, 49, 50, and 66. Any such kind of non-compliances where section 43, 45, 49, 50, or 66 will be invoked or attracted, that will continue. But that will not impact the company. That will only impact the suspended management. So, approval can also be given for unapproved capital expenditure. The stocks and receivables have been misstated before the lenders. That can also be approved. So all these things can be approved, and all these non-compliances or violations of the terms and conditions of loans, that also can be ironed out, and that can be finally set it as right, because either the same management or the new management takes over the company. In the case of MSME, even the same management also can take over the company. But in the case of other companies, the new management can take over the company. However, all these misstatements given, wrong stock statement, wrong receivable statement, wrong creditor statement, wrong calculation of working capital, the drawing power, that also can be, everything can be cured or waived in a resolution plan. Now, this reduction in the amount payable to creditors, this is very, very common. Reduction that can be an operational creditor, financial creditor, any kind of creditor. There can be reduction, there can be change in the repayment period, there can be longer repayment period, there can be conversion of some of the debt into equity share, some of the debt into preferential share. This is all possible under a resolution plan. Now, the extension of maturity date or change in the interest rate or other debt from the corporate debtor, like that we also can be seen, like the working capital loans are converted into working capital term loans, and reduction in the interest rate, deferment of the repayment schedule, and complete holiday. Some kind of complete holiday can be given, that after the resolution plan is approved, maybe for 2 years there will not be any repayment. So when we see this amendment to the constitutional documents of the corporate director. Somebody say that I will convert the LLP into private limited. So whatever approval is required from the partners, that is not required in this case. And once the company's resolution plan is approved, the constitution of documents. So what I'm trying to say, why this is about part of the resolution plan? Because see, otherwise all these processes will require the approval of the creditors or approval of the shareholders or approval of the debenture holders or approval of the public deposit. All such kind of approvals would not be required if a resolution plan is approved and that constitutional document requires modification or amendment. So this is also a kind of uh, voluntary disclosure kind of a scheme. When once the company is into insolvency, please declare all kind of non-compliances, and also like any kind of shareholders agreement or joint venture agreement can be also considered as waived. Now, issuance of securities of the corporate debtor for cash, property, securities. Now, why this particular part is there in the resolution plan? Because see, so far the practical experiences says that nobody has ever issued securities, or even if some people have issued securities, this is not very popular. But then conceptually, this is very clearly available under Regulation 37 that the resolution plan can also propose the issue of equity share, preference shares, cumulative convertible preference share, debentures, bonds, etc. And that can be justified with the requirement of funds. And the certain properties can be acquired against fresh issue of securities. Certain claims of principal can be settled. Securities like share debentures can be issued against the fund-based or non-fund-based facilities. The removal of all those who are part of the resolution process would approval of all, as I said, who are part of the resolution process would not be required. However, the approval and other compliances of any other law would be required. That's what is my understanding. Change in the portfolio of goods or services produced or rendered. Normally, lenders do finance a project. Lenders will make a they will make an appraisal, and based on that appraisal, they will finance a project, and they will not allow the change in the portfolio of goods. So in this case, since the creditors are also part of the resolution process, so the such kind of changes in the structure of the company would also be possible. Then coming to K, the change in technology used by the corporator. This is like for this also, in case any shareholder or any bankers meet or bankers approval is required, that would not be applicable because that can be done through a resolution process. Necessary approvals from the central government, also approval pertaining to merger, acquisition, amalgamation, and that can be a part of the resolution plan. Industry-specific approvals may be required for some projects under implementation of projects, and resolution plan can have such a requirement. So this is again the same logic that the approval can be recommended by NCLT based on the viability of the resolution plan. However, separate application and following a process would be required for all the above relief. M is the sale of one or more assets of the corporate debtor. So this is also latest. This is latest insertion into the IBC regulations, and Regulation 37 has a new section now M, and it says that the resolution plan can be even for one asset. Resolution plan can be even for two assets. So that resolution plan itself, there can be multiple resolutions. Like we all know that in the case of HDIL, there are about 5 resolution plans. And then there is a liquidation application also. 5 resolution plan and there is a liquidation asset. So 5 resolution processes are gone, voted upon, and it was successfully voted upon. Then thereafter, even the balance company was proposed to be liquidated. Claim submission we've already discussed, and the approval is also discussed. So most important judgment for waivers, concessions, reliefs is the Gyan Mishra and Sons Private Limited versus Edelweiss. So this judgment talks about claims that no other claims can be received, and also talks about the government authorities. Government authorities shall stand extinguished, and no proceeding in respect of such view. Ankit, you have it at this moment. I think we can take some questions, and we should encourage people to understand. Like, see, otherwise, we will talk about ourselves on the various questions that we've been receiving from public at large. Yes,
Yeah,
please.
so I so I think I will start with a question from DSR IRP. The question is, can future cash flows from operations of the CD be a part of the resolution plan amount by resolution applicant? And I believe the answer is yes, that the
Yes, yes.
cash flows within the company are can always or rather or frequently part of the resolution plan itself. Uh, then we have Mr. Hari Prasad asking that can waiver of action against personal guarantors be made as one of the waivers? So this is something that I believe is part of a lot of resolution plans, where the resolution plans are coming in from promoters. So what is your experience with respect to the personal guarantors waiver?
So, one that there are unclad judgment which says that if there is a waiver for a waiver of personal guarantee, then in that case it will be if it is one lender, two lender, three lender, if they those lender approve, if those lender approve that the personal guarantee can also be waived, then it is viable. However, in case like take an example that there are four or five uh, lenders, secured lenders or unsecured lenders, and out of them some have the personal guarantee and some do not have the personal guarantee. So therefore, anyone who have personal guarantee would not like to say yes to this proposition that the promoters would be exempted or the that personal guarantee would stand cancelled. And however, in case of assignment of loans, in case the loans are assigned to another ARC or to another NBFC or any other company under the assignment contract, like in case we have to do it under the SARFAESI Act, then the assignment can only go to ARC. If we assign it to any other company, then it is not the SARFAESI Act, it is the Indian Contract Act under which the assignment will be done. So what we are now saying, like in case of assignment, in case of debts getting transferred, in that case, someone who is a dissenting creditor, he can actually object that once you take the assignment of the loan, then it will be very difficult for me to it will be very difficult for me to kind of pursue against my rights of personal guarantee. So that is not acceptable to lenders, and the NCLAT has also said that it is not possible that the personal guarantee can be waived where there are some dissenting creditors. If there is no dissenting creditor who have personal guarantee, then it is possible to also handle the personal guarantee in a resolution plan. But that only basically it is only subject to approval of all those creditors who have personal guarantee. Otherwise, it is objectionable.
And then whenever the resolution plan involves assignment of debt, is there that the transfer of the personal guarantee there becomes automatic, or there is a process
In case
to?
of assignment, the it actually becomes automatic because in the last 1 month, Delhi High Court has given a judgment which was argued and it was by Badwa Law Chambers. So, in fact, that particular order of Delhi High Court makes it very clear that once the assignment is done, then the lenders will have no right to proceed against the personal guarantor because there is no debt in their books, there is no
Hmm.
default in their books, so they can't default. They can't move against the main against the guarantor.
Okay. Next question is from Mr. Ravi. He's asking, can an amalgamation be part of the plan? Because this may require compliance of other provisions of Companies Act 2013.
So as I said, all those things where the shareholder approval is required, members approval is required, the venture holders approval is required, and the and the creditors approval is required, and also the approval of NCLT is required. All those things can be part of the same resolution plan. That can be reduction of the capital, then can be issue of capital, that can be extinguishment of the capital, uh, that can be even merger, demerger, or so all this can be uh, through a order from the NCLT, and that can be considered as valid. Uh, so I don't think there is any problem. It is only in some benches in India they are saying that in case of such things, you file a separate application for amalgamation merger, because under that uh, Companies Act, the tribunal is supposed to do some process before the company is amalgamated or the company is merged. So that will have to be done. So therefore, benches are insisting that they should actually the companies should file a separate application and should not merge it with the resolution plan. However, the uh, the information will be drawn from the resolution plan, and the resolutions which are required for this process of amalgamation or restructuring, that will be considered as already available with the company.
Then we have a question where the question is whether prayer for implementation of resolution plan subject to vacation of ED attachment, can it be considered a conditional plan? And can this stipulation be part of a resolution plan that it will be implemented after the ED attachment is vacated?
So I believe this is practically and legally possible, because see what we are doing is this ED has an attachment on the assets, and the ED has not taken the possession, and the possession is with the RP. Now let us understand what is the issue. One is that the title of the property cannot be transferred in any kind of, maybe a resolution plan or whatever. It's not possible because the assets are attached. However, the resolution plan can say that the management will be changed, the new management will come, the new management will operate the company, and new management will also be responsible or meaningful for the purpose of profits or loss of the company. So even if the ED's attachment is there, this particular transaction would not impact the attachment of ED. Attachment will continue. The action against the suspended management will also continue. The new management will be protected from the prosecution and criminal harassment. But the only thing that I want to say that it can become a resolution plan, and there can be a successful resolution applicant, and the successful resolution applicant can become the new management of the company. They can continue, they can start using the company, they can start using the infrastructure, and they can even revive the company. However, they should be very clear that the assets of this company are attached by the ED, maybe under PMLA or any other law. Yes, Ankit.
So then we have the next question as in case of this is from Raviji. In case of issuance of securities debentures by RA to existing lenders, how does release of charge no due certificate work out? So this is a case where debenture securities will be given by the RA, and how will the vacation or how will the charges with respect to the CD which is changing hands or whatever, how will that work? That's the question. So I believe that the routing needs to be done through the CD, right? Or is it possible that uh, during the resolution plan, the RA can issue some securities from the RA's company and the lenders release the charges on the CD? Is that also possible?
Yes, this is possible, because this requires only approval from creditors and approval from shareholders. And that is possible. Anything which requires approval from creditors, approval from shareholder, approval from debenture holders, that is possible, because they are all part of the resolution process, and it is uh, possible. However, the next process has to be done very clearly. The next process would be wherever the application is required to be filed for taking an order, that process is required.
Then Mr. Jain Ryan is asking that can there be a prayer to withdraw all puff applications against the I think suspended board of directors in case of application by promoters and MSME. I believe
Mhm.
rather than saying that we can have a prayer to withdraw the PUFE applications, there is a possibility that if the promoters are filing the resolution plan, can't they simply say in the resolution plan that if there is any result from the PUFE transactions, then the money will go to the promoters or the resolution applicants?
In most of the resolution plans, Ankit, there is a clause. In fact, we have put it as a mandatory clause of resolution RFRP. So what that clause is that we are saying, one, that any recovery from these uh, avoidance transaction applications that will be distributed to the creditors because they have lost the money in case there is a haircut. But in case there is no haircut, then we can decide who will take this money which is coming from the avoidance transaction. So
Mhm.
a should prove, resolution plan should provide for one that who will be responsible for continuation of the proceedings, who will be responsible for allocation of the proceeds. All this has to be mentioned in the resolution plan and the same will be approved.
Okay. Next question is that if the bank has settled the loan with the borrower, can the bank initiate recovery proceedings against guarantors who have given property guarantees? I think this depends on the settlement terms. If the settlement terms include all the guarantors' settlement as well, then this would not be possible. If the settlement says that the bank continues to have liberty to follow up for the balance loan with the guarantors, then that will continue. Am I right?
Yes, I believe banks changing the terms and conditions with the main primary lender, that is
Hmm.
possible. The bank can change the terms and conditions, and it is also the grunters. I have seen the grunters going to courts that the promoters have settled with the bank and have also kind of saved their personal properties. However, we are stuck up. So
Hmm.
if the bank is changing the terms and conditions, the bank should also consult us. But that's
Hmm.
not something which is upheld by the very courts, because the courts are saying that the guarantee agreement is a separately enforceable agreement and it has got nothing to do. However, whatever is recovered, that has to be reduced from the debt. Only the bank cannot claim more than what is due to bank. So if
Hmm.
anything is recovered in any loan, that of course will be uh, considered as recovered, and the proceedings of guarantee will only be against the balance amount.
Okay. And I think yeah, well, let's take one more question before continuing. So this is from Sanchit, and he's asking, there is a claim from GST department wherein a huge claim is raised by them on the basis of a show cause notice raised by them. Should IRP admit such claim of the GST department as this is yet to be determined or finalized? I believe we have talked about this before as well, that for an R for during the CRP process, it is a duty of the RP to verify the claim and admit all claims after it is verified. And the verification is our, I think, ambit. We are not supposed to value the claim or put anything like that. So if there is any reservations with respect to the fact that the claim or the demand is not final, the same can be part of the IM also. And I don't, I think that's what we could understand from previous discussion.
We continue this kind of questions from waivers, etc. So, what is the last question, Ankit?
Last question that I was asking was with respect to I think we can continue now. I think we can continue with the presentation. If there is any new question, I will bring it out.
Okay, so continuing with this, now we have listed various kinds of reliefs and waivers and
I will just check and try to connect him back. Mr. Goel is joining back in 2 minutes, so we will start shortly. There's a technical issue at his end.
Yes, Ankit.
Yeah, so I will just share the slide. You'll have to enable uh, you'll have to enable screen sharing with me.
Okay.
You can make me
Then
host, I think. You can just make me host if that's possible.
done that.
So here are we. This was, I think, where we were: relief, sought, or paid in the application.
So what I was saying, Ankit, this is a complete list of waivers, reliefs, and concessions
Hmm,
that we have seen in various orders of adjudicating authority and also various orders finally which has actually gone into appeal. And this is the final crux. Now, when we talk about each and every waiver, so we can see like the waivers of all claims, liabilities, obligations of guarantee, other than appearing. So this is the based on the claims process, as we have already explained the structure that the insolvency process is a structure of filing claims and admitting claims, and then the rest of the claims are lapsed and whatever claims have not been filed, those will not be filed again. All this is a structure, and based on this structure, this is a kind of waiver which is permitted, and this is all normally allowed.
hmm.
Now, the other part is the ROC shall waive of all penalties for non-compliance by the erstwhile management and to allow the new management to file the old reports such as balance sheets, annual reports, other returns, etc., without any penalty. Now, this is a past liabilities which is outstanding and gets settled as claims. However, there are certain liabilities which the ROC has not yet levied. Because see, then in that case, the ROC will definitely facilitate. In fact, for all these things which are regularly coming to the respective authorities, they have come out with their own processes where a resolution plan has been approved. So in the case of the ROC has come out with their own process where the resolution plan has been approved and they are kind of they are kind of understanding that the process has been approved, so they are waiving some of the penalties rather than taking the late filing penalties. They have carved out a process where the all the balance sheets of the past can be filed with GNL form. Ankit, you would be able to tell us better what actually the RMC formalities for filing past financial statements, past returns, and without any late filing penalty.
Yeah, so there's a form called GNL3 and GNL1, and that's filed with the requisite documents attached to it. And we have handled various processes where the resolution applicant has got the resolution plan approved from the NCLT. Then the process of updating the financial statements, filing everything with the ROC, and then updating all the records before the ROC, that becomes an important part of the entire process. So that is something that that's important to be taken care of then.
See, the other is the all approvals, licenses, and benefits in the name of the corporate debtor shall continue with the successful resolution applicant subject to payment of renewal fee without any penalties. So this will be handled in view of Section 31, Subsection 4 of the IBC, which clearly says that if any approval, license, or any kind of permissions are required for continuing the company as a going concern, those will be taken within a year from the approval of the resolution plan, or alternatively, if any time permitted in that particular law, if that time is more than 1 year, 2 year, 3 years, then the 3 year will be applicable. But in case that time is not there or the time is less than 1 year, then 1 year is given to successful resolution applicant to take those approvals and also to take those permissions. And during this period, no action can be taken against the corporate debtor for continuing the operation without those approvals or licenses.
Hmm.
So then is the successful resolution applicant shall not be responsible to any statutory liability outstanding as on the date of approval of the plan which arise due to past deeds. This again is being settled through the process of claims. Any claim which pertains to a period up to the approval of resolution plan by NCLT, by adjudicating authority, those all would be the responsibility of the one, that either it will be the responsibility of the suspended management, or it will be the responsibility of the resolution professional or the committee of creditors in case there are some non-compliances during CIRP period. For criminal non-compliances, it will be suspended management, and for financial liabilities which are not crystallized, or those are crystallized after the resolution plan is approved by the uh, adjudicating authority, those would be considered as waived because the claim pertains to the period which is before the approval of the resolution plan or before the CIRP commencement. Therefore, it is not possible to admit those claims as the SRA, the successful resolution applicant, is protected. Yes, Ankit, please go ahead, or we can take you in a question.
So,
Maybe next slide also, in case it is.
yeah, I will just go to the next slide. Yeah.
The SRA is entitled to get all rights, titles, and interest while the every part of the corporate debtor. So this is very well defined in a definition of property. So the definition of property is very important in the section 3, and that property means everything, every actionable claim, all this, actually every property of the company will continue to be owned by the company, and the new management will come, the new directors will come, the new shareholders will come. However, all rights, all assets, all property of the company will continue to be with the company, and the new management and the new shareholder will become the entitled for the benefit of those properties in the name of the company. So normally, it is written in the resolution plan that the SRA will get all properties. It is not the SRA will get all the properties. It is the company will continue to own all properties, and the company will change the management. Company will change the directors and the shareholders. Then actually the assets mentioned in the IM shall vest with the SRA of the corporate. This is wrong. The for the SRA is the ABC company, and the company and the corporate debtor is XYZ. So all the assets will remain in the name of XYZ. It will not go to the SRA. SRA will not become the owner of the asset. SRA is just a profile. The SRA will have the power to nominate directors. SRA will have the powers to SRA will have powers to nominate directors. SRA will have power to also nominate the shareholders. So now next the board of the corporate debtor would be reconstituted. This is automatic. The ROC will definitely facilitate reconstitution, and the adjudicating authority will empower monitoring committee or monitoring agency for uh, doing all formalities which are required for changing the director or removing the past directors. Yes, Ankit. Then waiver of past liabilities of investigation. As far as the investigation is concerned, that is something like the corporate debtor would be protected under Section 32 capital A of the IBC, but not the past management, not the key managerial personnel, not anyone else who was involved in that kind of fraudulent activities. All those cannot be waived. So whatever we are saying, it is all applicable to the financial liabilities and non-compliances, where see, in case we see the definition of claim, which is very important, any kind of a non-compliance where uh, the remedy where the remedy is basically a kind of right of payment. Maybe there is a contravention of an agreement, there is a contravention of warranty, maybe there is a contravention of a supply agreement. Every such contravention, every such kind of non-compliance, whatever results into a financial liability, whatever results into a payment, that is what is the definition of claim. So all kind of financial liabilities which might even arise out of guarantee, warranty,
out of shareholders agreement, out of joint venture agreement, out of supply agreement, out of customer agreement, out of any kind of damages, all this will result into financial liability, a right of payment. That is where the all the claimants will submit their claims, and those claims will be admitted and finally settled in a resolution plan. So anything which results into a prosecution is not part of the resolution plan. Anything which results into a fine, which is considered to be akin to a prosecution or a compounding, that is not a financial liability. That will not be a resolution plan. That cannot be waived. So the prosecution and fine, imprisonment, and compounding fee is not something which is a financial liability. That's not a right of payment. That's a prosecution, and the person actually gets that prosecution converted into some kind of compounding fee. That is not something which is considered to be a right which is converted into financial liability. So no claims can be filed for a compounding fee. No claims can be filed for any kind of prosecution to avoid prosecution. So there, it is very, very important to understand the entire concept. 32 capital A is for the investigations, and the company will be protected. The assets of the company will be protected after the resolution plan is approved or after the company is sold in the liquidation or assets are sold in the liquidation. Yes, Ankit, can we take some questions? Because I just wanted to make it very, very clear what kind of concessions are allowed. So normally, my issue that I'm saying, why most of the NCLT judgments are saying that we have no power to allow something which is to be allowed by the income tax department. We have no power to allow something which is in the power of the ROC. We have no power to allow which is in the powers of stamp duty registrar. So what we are saying is the adjudicating authority can say that this is the liquidation value of the company. These are the total claims. And according to the resolution plan, all these liabilities, all these claims are considered settled. Anything which is pertaining to a period before this would stand settled, and those claims cannot be admitted because there is again Shyam Mishra and Sons Private Limited versus Edelweiss judgment. Based on that judgment, the adjudicating authority at least can say that all those financial liabilities which have arisen, which have crystallized, or which may crystallize in future and pertains to a period before the adjudicating authority is approving this resolution plan, that would be considered as lapsed. Therefore, it is not really possible to say that the only those appropriate authority will decide. So when a SRA, when a successful resolution applicant goes to those appropriate authorities would not understand the concept of claims, the concept of claims lapsed, concept of claims settled, and the concept of Shyam Mishra and Sons Private Limited versus Edelweiss. That they would not understand. So to make it little easier for the successful resolution applicant, to make their life little more comfortable, if one paragraph is added in the orders that this is a situation of liquidation value, this is a situation of claims, and this is what is being held in the Shyam Mishra. So therefore, all those financial obligations, financial liabilities which pertains to a period, that will automatically stand waived. So this is what is my concept, Ankit. Anything that you can take up as a question?
So I think we are already up with time, but we can take one last question. That there might be, many liabilities which have not been finalized. It can be an arbitration proceedings. It can be some kind of an appeal pending with respect to GST or income tax and so on. So how do you seek waivers?
Absolutely,
or
a very, very
concessions on
important
that?
question. Very, very important question. First of all, my whatever I'm saying, my answer is based on the definition of claim. So anything which is pending, any liability which is pending, and which can result into a right of payment, that is where the claim can be admitted by the RP. And if the value of the claim is not crystallized, that can be accepted with 1 rupee. Then the RP is also under an obligation to classify that particular claim as an operational creditor, financial creditor, and a claim from workman or the employee, or a claim from government authorities, or claim from others. So once the classification is done,
in that classification, in that information memorandum, that dispute will be completely mentioned, and the expected liability in that case also would be mentioned. Now, now think of a situation that particular dispute has got a security interest, and that security interest value as per the asked claim is say 100 crores. Now, while distributability proceeds to secured creditor, that 100 crore claim should be considered. However, that will not be distributed. That will be distributed only after the final crystallization of that amount by the appropriate authority wherever that dispute is pending. We are not saying that the NCLT will decide all these arbitration claims. We are not saying that the NCLT will decide all property disputes. We are not saying that the NCLT will decide the dispute between the shareholders and between the directors. However, if there is a claim and that falls into the secured creditor, that claim will be admitted, appropriate distribution will be earmarked. However, the distribution will not be done till the time that dispute is settled. Similarly, for unsecured financial creditor, if there is a dispute and if there is an amount which is payable to unsecured financial creditor, that proportionate amount will be kept and it will not be distributed, and that amount will be kept with the monetary committee. That amount will be kept with the monetary committee. So this is what is very important. And suppose it's an operational creditor and there is a distribution to operational creditor to the extent of 1%, 2%, 5%, that amount will be kept separate with the monetary committee till the time that dispute is settled. And after that, the monetary committee will be closed. Okay?
Okay, sounds good. Sounds good. So I will stop sharing the screen, and I think it's already 12:05. So we should. You think we should close today's session?
Close, and we apologize. We apologize that my laptop went mobile. So this is, I think, the concept was to be completed. So we have completed. So this is what we wanted. That understanding about the waivers and concessions should be spread around the professional colleagues and the lawyers and also the committee of creditors. So thank you very much, the audience participants, for giving us your time. Thank you.
Thank you, everyone. Thank you so much.